Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Good afternoon and welcome to our Third Thursday webinar. My name is Josh Pettingill. I will be your host for the next 45 minutes. Before we get started, I would encourage all of you to write down your questions because there will be a Q&A session after this presentation. Appreciate everyone joining us. Let's get into it. Liability Medicare Setasides. Is it time to start worrying? That is the big question. Well, I can tell you that we are in mediations every single day. We are in the trenches. And for those attorneys that don't yet have their own internal guidelines for screening Medicare beneficiaries, it is time to start worrying. The good news is by the time this presentation is completed, you will have the tools necessary to get moving on your own Medicare compliance program internally for your law firm. Now, today's presentation is going to be about Medicare Secondary Payer Compliance. We have nurses on staff that do nothing but prepare Medicare Set Aside reports so you can resolve your cases and be compliant with the MSP statute. We also offer settlement consulting, government benefit preservation services, trust services, structured settlements, tax deferral fees, and lien resolution. And we also, on a regular basis, are doing Third Thursday webinars on these topics, as well as offering complimentary CLEs to your law firms. We're happy to come in, meet with your staff, meet with your attorneys, meet with your paralegals, meet with anyone who's touching these files to educate them on these respective services. Reach out to us after this presentation if you're interested in doing that. Again, my name is Josh Pettingill. I'm one of the founding principals of Synergy Settlement Services. I'm also Vice President of Medicare Secondary Payer Compliance. And I've handled over 10,000 cases as it relates to Medicare Secondary Payer Compliance with unique circumstances over the years. I'm also the immediate past chairperson of the Liability Medicare Secondary Payer Advisory Committee for the group NAMSAP, which is the National Alliance of Medicare Set Aside Professionals, which you see a picture of me here giving a presentation just last week in Baltimore. And I will get back to that presentation as we go through this today. Here's our hit list and agenda for this afternoon. Number one, we're going to fly through the most recent activity out of CMS and out of Medicare. I'm going to give you some important case law that you can keep in your back pocket for when you're negotiating these cases. We're going to hit some case examples, some real world scenarios that you see every day in your practice. Number four, we're going to wrap things up with best practices for making sure your law firm is protected. What in the world has been going on the last 10 years as it relates to liability Medicare set-asides? Well, the answer to that is a lot, frankly. And we are going to hit all of those things today. Stay with me as we fly through these initial slides and get to where we need to be and what you need to hear and understand for your own practice. By now, everyone listening on this webinar should know that a Medicare set-aside is never required by any law or by any statute that exists. The same can be said even in workers' comp cases where all this stems from. In workers' comp, a Medicare set-aside is never required. It's just become the de facto mechanism for settling a complex case involving a Medicare beneficiary. When that happens, a Medicare set-aside report is completed and is submitted to Medicare for their review and blessing. They approve it. You've got that stamp of approval, and you know without a doubt that that number is not going to get any higher. There's a mechanism in place to have those reviewed. As it relates to liability cases, we do not have that yet. It's a very gray area. The background of this slide is gray, and appropriately so because that's how liability space is right now. We call it the case after the case. A lot of you here today listening have seen this firsthand in your practice where you work so hard for your clients to get them a good recovery, and then next thing you know, your case is being delayed by this Medicare secondary payer issue, whether it be on the conditional payment side, whether it be on the future side, but your cases are being delayed. And for those of you that have attempted to even get Medicare's approving their Medicare Set Aside, you would have seen firsthand that very rarely do they actually review them. There have been a few occasions where we had a large 7-figure or 8-figure settlement with a very de minimis Medicare Set Aside, comparatively speaking, where we've submitted it for Medicare review and approval, knowing that certain regional offices will bless them and we've gotten their approval, but for the most part, they won't even respond to it because their resources are completely tapped out. This is a letter we received recently on a liability Medicare set aside submission. Our client wanted us to try to get Medicare's review and blessing for a number. We submitted this to Medicare and the BCRC, which does these reviews, and this is the letter we got back. The long and the short of it was this: Medicare doesn't have the resources to review this. The BCRC does not have the authority to make that determination. Oh, by the way, please make sure our conditional payments are resolved. When you settle this case, if you have any questions, give us a call. Well, we're probably going to tell you nothing. This is the response, and this is the same response we've been getting for over 10 years in trying to do liability MSAs and get Medicare's approval. Have we gotten Medicare's approval? Absolutely. Do we very rarely do it? Absolutely, because we don't recommend it, because getting Medicare's approval on a case is voluntary process. You don't ever have to do it. And oh, by the way, getting Medicare's approval on a workers' comp MSA is still voluntary. You're never, ever required to do it. That's the big difference in liability and workers' comp, is that in workers' comp, there is a framework in place for when a submission is done and approval is done. If the case is settling for $25,000 or more and the client's a current Medicare beneficiary, or if the case is settling for $250,000 or more and there's a reasonable expectation within 30 months of being on Medicare, Medicare will actually take the time to review and approve an MSA if it's submitted. Now, I want to break down the differences between what the defense thinks is involved as it relates to Medicare set-asides versus what the real responsibilities are by the plaintiff. Number one, the defense's job is to report the case under Section 111 reporting requirement. Medicare has said this over and over, most recently in a policy memorandum, that it is the job of the carrier to report the case and identify Medicare beneficiaries. It is plaintiff's responsibility to identify whether or not future medicals are funded, and if so, whether or not the Medicare trust fund has to be protected. They made it clear that the Medicare set-aside issue is a plaintiff's responsibility. And the worst case scenario that could happen in all this is that nothing is set aside as it relates to Medicare's futures. Your client goes to get treatment after you've cut them a nice check from all the hard work that you've done. They go to get care, go get a surgery, go get that medication, Medicare denies it. And your client comes back at you and says, why didn't you tell me about this issue? And then you could potentially have a legal malpractice claim on your hands. And Medicare is denying claims right now. We have seen some instances where Medicare has actually denied claims. So it is happening. So when the defense gets involved in Medicare set aside, oftentimes they're wanting a fully funded Medicare set aside. They don't understand the concept of limited coverage, comparative fault, life expectancy, real world pricing. By default, all they want to do is fully fund a Medicare set aside immediately for someone who's a Medicare beneficiary, or they want your client to get a letter saying there's no future care recommended or needed. There is a policy memorandum that exists that says if you can get a letter from the treating doc that says there's no care necessary as it relates to this accident, there's no need to do a Medicare set aside. And if you want, I can send you some template language after this presentation you can put in your file so you can get that letter in the appropriate circumstances. Now, oftentimes it's impossible to get that letter because doctors, once they've rendered an opinion, don't want to go back on that opinion, and rightfully so. But in lieu of getting a letter from the treating doc, one thing you can do is get a zero Medicare set aside, which is literally a Medicare set aside report that has a zero balance on there, or a no Medicare set aside letter, or what we call a Medicare set aside evaluation letter. We can do this for your file. that says for the following reasons, there's no need to do a Medicare set aside. You put that in your file, you document your file, and you go on to the next case. But at least you have something in your file that shows that Medicare's interests were considered. Now, going back to what a Medicare set aside is and what it looks like, at the end of the day, when we're doing a Medicare set aside, our goal is to get the lowest possible number post settlement. That way, your client gets the most money in their pocket free and clear, right? And there are a lot of factors that come into play that influence what that ultimate number is going to be. But all of that has to go into the calculation. You can't simply just give a number, because the methodology that Medicare has in place right now for doing a workers' comp Medicare set aside assumes a 100% recover dollar for dollar, which we never get in a liability case. Arguably, every single liability settlement or recovery settles for a compromised amount, and that gives us some flexibility to reduce our number. So from the defense's side, they're also trying to get our clients to sign ridiculous release language that sometimes prohibits them from applying for disability benefits, prohibits them from trying to bill Medicare, et cetera, et cetera. These are scare tactics. And from our standpoint, we're approaching Medicare set-asides as an insurance policy. It's all it is, simply an insurance policy. If Medicare continues to make payments on behalf of your client, guess what? Your client has done nothing wrong. Because as we already established, a Medicare set-aside is never required by any statute or by any law. But if Medicare ever came back down the road and said, we shouldn't have made this payment, or we're going to stop paying benefits for you, a Medicare set-aside is a good faith number, a reasonable amount that adequately considers Medicare's interest. It's like a deductible in the sense that once that money's been spent and spent appropriately, Medicare is back on the tab to start paying again. If you remember anything about this presentation, you remember that you have to be proactive on these issues as it relates to Medicare Secondary Payer Compliance. Over the last 18 months, there's been 3 different times where the government has made examples of different law firms for failing to consider Medicare's interest properly at the time of settlement. Now, on top of that, they've actually gone into these firms and said, look, you've got to start a compliance program internally to be able to settle these cases and handle them appropriately. And all of these firms, by the way, that have gotten tagged are not a Synergy client. If you can believe that, I'm sure you can. But it's incumbent upon you as trial attorneys and plaintiffs' counsel to start establishing these type of programs internally for your cases, so you know how to screen them properly, identify them properly, and handle them properly as they come in the door, not when they're settling, as they come into the door. Now, as of yet, the government has not made any examples of futures, and as it relates to liability Medicare set-asides, it's only been conditional payments. Now, is it going to happen going forward? There is that possibility, but it hasn't happened yet. There's no case law out there that exists on an attorney being sued by the government or an attorney being sued by their former clients for having their benefits denied. They just don't exist. We don't have time today to go through all of the relevant case law, but I've highlighted the most important ones that I think you should take note of and put in your back pocket when you're negotiating cases. First one is Benoit versus Neustrom, or Benoit versus Neustrom. This is a case out of Louisiana. First case we had where a judge looked at all the facts of the case and actually apportioned out a Medicare set-aside in a liability case. Alborn versus Arkansas. Many of you are familiar with this case. For those of you that have handled Medicaid liens, this is an equitable distribution type case. Bradley versus Sebelius, another type of equitable distribution type case as relates to conditional payments for Medicare liens. Harenke versus Burwell, which is a famous case for when a judge said there's no need to do a Medicare set-aside, which we already knew existed because the government and Medicare told us that. But if you're interested in these case citations, I will send them to you. I have the full case workups, and I'll send them to you after this presentation is over. Just let me know. So since 2016, it's been a lot of hot and heavy talk about liability Medicare set-asides. They first issued something back in July. It said they issued this short and sweet little note. It said CMS is considering expanding its voluntary review process to include liability Medicare set-asides. A few months later, they put out this request for a new review contractor, and in that draft request, they asked for whoever's going to be the review contractor to be able to review liability Medicare set-asides, as well as provide feedback and guidance on liability cases. That new contractor is now in place. They've been in place since last June. Then a few months later, we got this scary notice from the Medicare Learning Network that said Medicare is set to reject claims starting October 2017 on the basis they should be paid out of liability Medicare Set Aside. This is a notice that went out to all the medical community. October 2017 came around, nothing happened, and there was no reports of a greater uptick in denials. Then in September 2017, a new contractor was hired to the tune of $60 million, whereas the previous contractor had a $5 million contract. And our interpretation of that was there are going to be a heck of a lot more cases that they'll be handling, hence the higher contract reward. And those cases coming from the liability side, which is a much larger space than the workers. In 2018, things got really interesting. CMS held some private meetings with some key stakeholders. Those key stakeholders being the AAJ, which is the largest plaintiff community, as we all know in this call, on this webinar, and the insurance industry. And then the third group was NAMSAP, the National Alliance of Medicare Set Aside Professionals. It's the only organization in the country that's dedicated to Medicare professionals. Okay, those three groups: AAJ, the insurance industry, and NAMSAP. And in those meetings, they said, here's what we're thinking. Do you have any ideas? Because we want to talk about these liability Medicare set-asides, and we're going ahead and moving forward with doing something as it relates to liability Medicare set-asides. Then in December 2018, we got this notice of proposed rulemaking. Here's what this announcement said, that there would be a proposed rule for protecting the Medicare Trust Fund, and it would relate to liability cases and beneficiaries and how the Medicare Trust Fund should be protected. Some of you may recall back in 2012, there was an advance notice of proposed rulemaking, which was very similar to the one that was just issued. And in 2014, CMS actually withdrew this notice of proposed rulemaking. But during that time, from 2012 to 2014, over a 2-year process, there was all this discussion about liability Medicare set-asides. And during that time frame, they solicited key stakeholders in a public forum and asked for feedback and commentary on how to handle liability Medicare set-asides. And I'm proud to say that we were very involved in providing them feedback and guidance. We worked very closely with AAJ and national trial lawyer groups all across the country to, number one, fight this issue and say that they don't have the rights to do this, and number two, if they were going to do this, here's what the framework should look like. So this is the second round or second go around of this notice of proposed rulemaking some 5 years later. But the NPRMs have to work its way through a process. And the next steps, there's a notice of inquiry, followed by a period where there's comments solicited, much like there was a few years ago. Then a report and order is issued, and then it actually becomes a ruling. So this was a surprise in the sense that we already received a notice of proposed rulemaking on liability cases years and years ago. And at the time, Medicare made an attempt. It was its first attempt to try to get some guidelines in place for liability MSAs, but they weren't able to do that. After over a 2-year period, they said, you know what, we're going to keep everything the way it is. And at the time, the market celebrated that and thought that there was no need to do a Medicare set-aside or even consider one. But we issued a report after that came out and said, look, nothing has changed in the sense that Medicare always has the statutory right to deny benefits under the Medicare Secondary Payer Statute. Anytime Medicare issues one of their policy statements or announcements, they always cite MSP statute. And even though they withdrew their notice of proposed rulemaking, no rules ever took effect, it still doesn't change the fact that they could potentially deny benefits post-settlement for accident-related care. Which brings us to Baltimore, September 2019. The setting is the National Alliance of Medicare Set Aside Professionals. The keynote speaker is a gentleman by the name of John Albert, who had spoken previously at the annual conference. In attendance were the top professionals in the country as it relates to Medicare Secondary Payer Compliance, over 200 to 250 of them, they said. But in the audience were also the top officials from CMS, which was very important. And we were humbly asked to present on liability Medicare set-asides and the current status of them and what's happening today. Now, we've been asked previously to do that. My partner Jason Lazarus spoke at this conference before, as have I. But this year, I gave the address, and as I got off the stage, I ran into one of the officials from Medicare, and he stopped me. He said, "Josh, I was biting my tongue the entire time you were up there." And I said, "Oh, no, that can't be good." He said, No, it's not terrible." I said, "What does that mean?" He said, "Well, we are, quote, ready to go on formal guidelines." His words were ready to go. He said, and on top of that, we've listened to all the comments that we've received from the marketplace, from all the key stakeholders. We've applied what we learned the first go around, and we've integrated all that into formal guidelines and we're ready to go. He was upset because the NPRM got rolled out and now it has to work its way through that process because that's going to cause further delays. Otherwise, this would have been released already to the public, but now it's got to work its way through the NPRM process. What does that program look like potentially as far as a formal guidelines and a formal framework? Well, it's going to be voluntary like it is in workers' comp. And like we said in workers' comp, the review process is completely voluntary. The purpose of it would be to protect entitlements to Medicare benefits. And this would be done and take place after a settlement is reached. So you couldn't do this before a case settled to get a number. You'd have to worry about the MSA issue post-settlement. And it may also apply to beneficiaries that have a reasonable expectation, much like they have. Some further guidance that they gave us in those meetings were that this is going to be a plaintiff issue. All these problems, all the issues you've been having with the carriers because they've been scared to death of Medicare, CMS has said, look, we're going to make it very clear that this is a liability MSA, is a plaintiff issue. And the defendant's job is to report the case, and they are not a target by Medicare. As I stated earlier, the worst thing that can happen is a client gets a nice check, goes to have treatment, that treatment gets denied, that client comes back to you, and that Medicare says, look, we consider the whole entire settlement to be a Medicare set aside because you didn't do anything on the front end. And you get tagged with a legal malpractice case. We don't want that to happen. Now, CMS has indicated their enforcement mechanism throughout this process is a denial. So they have said, and in that same forum have said, look, we haven't been denying cases on a regular basis. They said that in the private and public meetings, that they haven't been doing that because they don't have the resources to do it on a full scale. But that could change at any day, at any given point. Remember, they have the $60 million contract with the current review contractor. They can always add resources there. But they also said that they're going to be publishing what's called a reference guide. As it relates today and stands today, there's a workers' comp reference guide that we rely on for doing Medicare set aside, preparing them, submitting them, administering them, and that the same will be done for liability cases. And about a year and a half ago, 2 years ago, I was part of an invite-only group that actually drafted and helped prepare a liability Medicare set aside reference guide for Medicare's review to eventually incorporate at some point. And I don't know what ever happened to that. I know it got in the hands of CMS, and hopefully they took some of our advice in that regard. The key takeaway from this presentation is you need to be ready, folks, for this to happen. You need to be prepared now, not 6 months from now, not a year from now when this ever comes out. You need to be prepared now to identify Medicare beneficiaries, how you're going to process them, how you're going to deal with them, how you're going to talk to your clients about them. Before the case even gets to a point of settlement, it has to be happening on the front end. And one of the most common examples that we receive calls on are Medicare Advantage plans. For those of you not familiar with Medicare Advantage plans, they're called Part C plans. We often refer to them as a hidden lien as it relates to conditional payments because these Medicare Advantage plans are administered through private health insurance companies. They don't go through traditional Medicare. A client of ours called us a few weeks ago and had settled a case for $250,000. Their client was a current Medicare beneficiary. She was 71 years old and on a Medicare Advantage plan. And what makes this a little bit more unique than the average case is that this doctor had actually quantified the future medical costs as it relates to this accident of being $7,500. So the attorney called us and said, Josh, do I need to do a Medicare set aside? So our litmus test when we do a Medicare set aside or even recommend considering one is number one, is the client a Medicare beneficiary or is the client Medicare eligible? Number two, is there future care claimed, recommended, or necessary? And number three, are there actually any dollars earmarked or towards future medical care? If the answer is yes to all three of those things, you want to certainly consider doing some type of carve out in the form of a Medicare set aside. Now, this attorney actually went above and beyond and reached out to the healthcare plan and said, do we need to worry about doing a Medicare set aside? Please confirm that Optum does not require Medicare set aside for future accident related treatment. And he responded, that is correct. We'll not be looking for a Medicare set aside. And he asked specifically, does the plan address Medicare set aside issues? And he responded, here's our language contained in our settlement letter. And first off, Optum is a vendor for United Healthcare. They don't even represent or have the authority to make these calls, but yet you have this person clearly communicating back to our client that there's nothing to worry about and that they will be providing future care to this client, assuming that their lien is paid back. So what's interesting about this case is that ultimately we said to the attorney, look, your client's on Medicare. They could always switch out of a Medicare Advantage plan. Obviously, there's future care needs, and obviously there's some money left over to cover that $7,500. So what we did was, instead of doing a full-blown report, we had the client do a consultation with us, and we prepared what's called a self-administration waiver. Our fee is $1,000 to do that waiver process and consult, where we walk the clients through what they need to do. We prepare a comprehensive waiver. And what we did ultimately was the client agreed to set aside $2,500, which is a discount on the $7,500, and that was to account for the full value of the case being much higher than what the case settled for, and to take into account fees, liens, costs, and what the ultimate net was to the client. So the file was documented properly. The client agreed to set aside in a self-administered account this money, and the attorney went on to the next case. Now, why do we recommend a Medicare set-aside when the client had a private health insurance plan through a Medicare Advantage provider? Well, according to the Workers' Compensation Medicare Set-Aside Reference Guide, Medicare still recommends a Medicare set-aside in these situations because the plan could always be canceled or the coverage could be changed and they could opt back into traditional Medicare, and then therefore the burden is shifted to Medicare again. You'll notice in that illustration, that example, that we did not do a formal Medicare set-aside report. And there are some firms out there that would have recommended that situation, that the client spent a couple $1,000 to do a full-blown report, that they also submitted to Medicare for review and approval. I'm getting calls daily for these types of recommendations, which is asinine. At the end of the day, our goal is to make sure your clients are protected, you're protected, but also that you get the most money and your client gets the most money in their pocket free and clear. A Medicare set-aside is simply a carve-out of monies earmarked to consider Medicare's interest. If we can justify the amount, that's the most important thing, and we did that here on that case. But what are the best practices going forward, and what do you need to do as a trial lawyer to protect your own practice? You got to start early. Got to start early identifying these cases. When they come in the door, what kind of benefits are they receiving? Is it Medicare? Is it a Medicare Advantage plan? Is it Medicaid? Is it TRICARE? Is it VA? Is it all the above? Those cases are out there, and God bless our clients. Most of them have no idea what they are receiving. And there's an easy way to determine eligibility for a client. If you want, I can send you a one-page document that they can take down to their local Social Security offices, and in 5 minutes, they can be told what they qualify for. Control the process from start to finish. I'm talking liens. I'm talking determining whether or not there's going to be a Medicare set aside. contact the adjuster, contact the defense attorney. Once you know who they are, who you're going to be dealing with, that look, we're going to control the MSP process. That way there are no delays in settling your case. You can never, ever rely on opposing sides experts. You would never rely on opposing party's life care plan or economist report. So why would you do that for Medicare Secondary Payer Compliance? I can't tell you how many times that we've had to get involved at the 11th hour, come in and regulate as far as what needs to be done in the MSP compliance issues, because the defense has hired somebody who's a quote unquote expert who's never done a liability Medicare set aside. And is trying to jam a 100% full value Medicare set aside down our clients' throats where they're going to net $0 at the end of the day if they had to rely on that report. Get your own expert involved. The earlier the better for us as it relates to MSP compliance. We can help you control the process and help you clients get the most money in their pockets while being compliant. Medicare Advantage liens. Guys, we highlighted 3 different cases early on in this process recently where the government went after law firms. It's very simple. You got a Medicare lien, make sure it's taken care of. If you have a situation where you go on the Medicare portal and see that there's a very low lien or no lien or zero balance lien, you can know without a doubt that there's some other coverage in play, whether it be a private health insurance plan or some type of Medicare Advantage plan, which again we call the hidden liens, but go out there and find those. You can't find that information on the portal, but they exist. When a case does settle, make sure the correct data gets reported. I've been dealing with a lot of these cases recently where we don't know what gets reported. The defendant's job is to report the case, yet you never know what they're reporting or when they're reporting or if they're reporting at all. But at the end of the day, you can certainly make sure that the release is documented with a proper ICD code so that if 6 months or a year or 2 years down the road, your client goes to get treatment, that something's not going to get denied for being compensable to the accident when it really wasn't. And document your file to the nth degree. Document. Whether you're doing an MSA or not doing an MSA, document as to why you're not, document as to why you are. And get connected with CMS. CMS provides updates. You can go on their website and sign up for all their updates they send out. And stay tuned with us. We're on the inside. We're dealing firsthand with this stuff every single day. We're getting insider knowledge. We're dealing with these folks. Sign up for updates. We'll come to your law firm. We'll train your staff to use the portal. We'll train your staff to set up protocols. We'll all do all this free of charge. Here are some of the services that we offer as a firm. Medicare Set Aside evaluation letter. We can look at your files to see if there needs to be anything done. And if it's determined that there's no need to do a Medicare Set Aside, we'll put that in a letter saying, look, for these reasons, there's no need to consider doing a Medicare Set Aside. You put that in your file. You go on to the next case. Medicare Set Aside consultation and waiver. Oftentimes, if you don't want to make that decision on behalf of your client, you can put it back on your client to say, look, I'm going to bring in an expert who's going to explain everything to you, and you're going to make that call whether or not you want to protect Medicare's interests. Put it back on them. It's their decision ultimately. We're going to come in, talk to them for 45 minutes on a phone call or in person. Say, look, here's your options. At the end of the day, a Medicare Set Aside is an insurance policy for you. If Medicare ever comes back and denies something, you got this money set aside. It's never going to cost you anything more than that. Oh, by the way, we're going to fight that battle if Medicare comes back and says you owe us more money. That's what you're paying us for. And if they say, Josh, thanks, but no thanks, we'll put together a very comprehensive waiver. It says the trial attorney recommended this client do this. They elected on their own not to do that after speaking with a Medicare Set Aside professional that's approved by CMS. And put that waiver in your file, go on to the next case. The third option is if they say, Josh, you know what? I do have some concern about this. I want to address this issue. I do want to do a Medicare Set Aside. We'll get involved. We'll look at all the medical records. We'll look at the payouts. We'll look at what the medications are taking, and we'll put together a report. Looks a lot like a life care plan, but it's only going to show the Medicare allowable items, and it's going to ultimately come up with the lowest number we can recommend that protects everybody post-settlement. And that's all you can do. That's best practices. Again, Medicare eligible client, number one. Number two, there's some future care there that's going to be necessary or recommended. Number three, there's actually some dollars left over, which is easier said than done sometimes to identify. It can be very subjective. But if the answer is yes to all three of those things, a Medicare set aside is the best protection. Finally, if you have a client that is not eligible for Medicare, or maybe you have a situation where the other side has done a Medicare set aside, we can do a medical cost projection where we can quantify all damages, whether it be Medicare covered or non-Medicare covered. Looks and functions a lot like a life care plan. It's a great way to establish damages, and we can help you do that as part of your negotiations. And ultimately, the best protection for a client, so you have the peace of mind that your client's benefits are never going to be disrupted, is Medicare administration, Medicare Set Aside administration. So we would do this through a trust solution that we have, and it's the best protection for your client. There's a professional trustee, there's a Medicare Set Aside administrator that helps negotiate those bills with their providers, keep track of all those expenditures, file annual accountings with Medicare, file disputes with Medicare if need be, fight with doctors and providers if need be on the costs, and all that can be done for a very low cost of sometimes a little $1,000 to a couple $1,000 for the lifetime of that client. Very inexpensive. And we also want to provide complimentary training for your law firms. At the end of the day, we hope that you will be calling us, obviously, for our guidance, but we also give back to our clients, and we're happy to do that, whether it be some type of training. We can walk them through these CLEs similar to this one. We also offer other complimentary CLEs on special needs trusts, settlement planning, lien resolution, attorney fee deferrals, structured settlements, etc., etc. All this can be done as part of your firm. We're happy to do it. Our end goal when we get involved in a case is either to walk away from that case with a 0 MSA, a no Medicare set aside, or a low MSA, because all of those things equal more money for your clients, free and clear. And there are a lot of ways that we end up getting the lowest MSA, and you'll be surprised there are a lot of situations where, in fact, you don't need to do a Medicare set aside, even with Medicare beneficiaries. Here's an example of a recent case. There was a $500,000 policy. There were all the policy limits that were in play. The defense on this case proposed $116,000 Medicare set aside. Oh, by the way, that was proposed at the time the release was being drafted and submitted for the first time and reviewed by our client for the first time. It was never discussed, first off. Second off, there was 15 pages literally of Medicare protective language, indemnified language for the defendant, nothing that protected the plaintiff. We got involved. We reworked the entire release, make sure the language was appropriate for our clients and protected our clients, the law firm, and the plaintiff themselves. We got involved, evaluated the medical records, looked at all the facts of the case, and ultimately recommended a Medicare set aside of less than $7,200. That's real money savings that went right in the client's pocket. The client couldn't have been happier with the result. Ultimately, those funds were set aside, and the client decided, look, I'm going to take a wait and see approach. If Medicare continues to pay, I'll be happy with that, but I know I have the protection of this money that if they do come back and say they should not have paid, or they come back and say we're going to stop paying, I know that I'm covered and I have this money set aside. I'm not going to touch it, and then I will be protected. At this time, I'm going to hit the pause button and take some questions. Here's our contact information, or you can visit us online. We are happy to come to your office, as I said, to do a CLE. Send us your calls, send us your questions, and send us your cases. And we're grateful for the opportunity to work with you. And a lot of our time is spent on the phone just answering specific questions. Please take advantage of that. My partners and I are always here for you to help any way we can. Thank you so much for listening to this presentation.
language for a doctor as well as the Social Security. We'll definitely send all that out to everybody that attended. And then the next question was, if there's a special needs trust, what happens to the Medicare Set Aside? How is it handled? So we didn't talk about dual eligibility on this call today, but if the client's on Medicaid and Medicare and a special needs trust is being set up, oftentimes we'll do a sub-trust with a Medicare Set Aside account within the sub-trust, or there are times we'll do a standalone separate Medicare Set Aside special needs trust. We offer those in-house. Very low cost to set up, depending on the client's situation. That's how those are handled. And next question was, explain in more detail about the ICD codes and how and what gets reported. How do we find out what their defense is reporting? Well, that's a tough question, a good question at that. You don't know what they're going to report unless you give them the information and rely on that information. They're going to report the correct stuff. So what we're telling our folks is give them the ICD codes so they put them in the release, and make sure that at the end of the day that they're documented in the release, that if something were to happen down the road, the proof's in the pudding, that these are the ICD codes that were actually compensable as it relates to this claim. The bigger issue that we're coming across is that you're settling a case and the defendant is running to report that case, or they're running to report that case before the case is officially settled, and it's triggering a final demand versus triggering a conditional payment notice. And you've got to be clear on the front end when you're negotiating your case that if this case were to settle, that they're not to rush out and report the claim unless it's agreed upon by all sides, because it's causing havoc for some of our clients, because once that final demand is triggered, you have 60 days to pay that lien or the juice starts running. So I would encourage all of you on the front end, as part of your demand or even in the second step, building into your mediation agreement if there is one, then that they're not going to rush to report the case before it's done or prematurely. The next question we got was, if we're preparing a medical cost projection, at what rate is it prepared? Is it the market rate or the Medicare rate? Another great question. So if we're doing a medical cost projection, we're going to quantify both Medicare and non-Medicare items typically in that report. And the purpose of a medical cost projection oftentimes, obviously, is to function much like a life care plan, almost like an abbreviated life care plan for a fraction of the cost. The only difference is we're basing on a review of medical records. Sometimes we're actually interviewing the plaintiffs themselves. And we'll usually price that at the market rate because, again, it's typically used as a way to establish damages as part of any negotiations. But if we're doing it in workers' comp, we'll price it at the workers' comp fee schedule. If at the end of the day we're pricing a Medicare Set Aside, one of the things that we do is we price as close as possible to Medicare allowable rates, because those are the real world rates. And another thing that wasn't mentioned early on in this conference was, going forward, when Medicare rolls this stuff out, at what rate are we going to have to price these things out at? And Medicare addressed that in their meetings and said, we're going to be able to publish a Medicare rate guide. And one of the things they've allegedly promised, is that it's no longer be priced at these obscene fee schedules, which makes these numbers gigantic coming out of the gate. So that is one positive. The other news that came out just yesterday from CMS relates to the NPRM, and that was supposed to be rolled out before the end of year. End of year now is almost completed, and now they've gone back and said we're going to push that back to February 2020. That literally just came out yesterday, that they made that announcement that they're pushing the NPRM release to 2020 in February. So we have some more time, and that was expected based on everything that I've talked about with CMS and everything I've heard and seen firsthand. That was completely expected and in line with what we talked about earlier. And we got some more questions coming in. Can you give me some examples of what to look for release language that you never agreed to? Great question. So some of the things that we see oftentimes is that your client is going to refuse to apply for Social Security disability benefits or SSI benefits, handcuffing them essentially from doing that. Most commonly, we see that the plaintiff agrees that they're never going to bill Medicare for anything. Another thing that we see oftentimes is that Medicare can potentially deny all future care for a plaintiff if nothing is done, which is completely false, because as it relates to these issues, Medicare can only deny things that are accident-related care potentially. So those are some examples. There's countless more examples. I've got a couple articles out there on release language. If you're interested, just just reach out and I will get those to you. I think that's all the time we have for today. But if you have any other questions, there's a bunch more here, but if you have any other questions, please send them to us directly. We've got your contact information. And thanks again for participating today.